It's a great pleasure to welcome Kathy Reese back to our stage. Kathy has ensured that we've been putting a spotlight on environmental distress and the opportunities and its impact in our industry. And I know today she's going to talk about three significant cases. So I think, Kathy, you're going to talk about Tronex, about Rechthold and Veris Gold, and thank you for ensuring and your persistence in ensuring that we stay on top of this subject. I'm looking forward to the session. Thank you.
Mining is always a topic I try and bring up because I'm in the middle of the distressed mining industry, whether it's gold, silver, copper, because I live in Phoenix and our major practices are in Arizona and Nevada and Colorado, where the major cases tend to be either worked out or tend to be involved, along with the environmental agencies. And so I'm delighted to have a chance today to have us deal with at least one of the mining cases. So we're going to cover several things. And we'll let Dawn, why don't you introduce yourself first, and then we'll have each person on the panel. Dawn Cica from Fox Rothschild first.
Hi, I'm Dawn Cica from Fox Rothschild. We're a fairly large firm, 700 lawyers in 24 offices. I practice in the Nevada, the California, and the New York offices in restructuring, M&A, real estate, and financial, the financial group.
Annette Jarvis from Dorsey.
Yeah. I'm a partner at Dorsey and Whitney. I'm in the finance and restructuring department, and I've practiced bankruptcy and restructuring law for over 30 years. I sit on the firm's management committee and oversee the finance and restructuring department, and we have 19 offices internationally.
And Bob.
Hi, I'm Bob Del Genio. I'm managing member of CDG Group. We're a financial advisory firm based in New York, work on both financial advisory, interim management, as well as distressed investment banking.
And I'm Kathy Reese from Fenimore Craig, and as I said, I'm from Phoenix. Our offices are the mountain regions, so it's Arizona, Nevada, and Colorado. And we have a heavy practice in natural resources, as well as in securities and the issues that deal with that, and real estate. Those tend to be very large problems in our area. I chair the financial restructuring, bankruptcy and creditors' rights group, and so I look at all the different alternatives that you have to use in order to deal with a environmental problem. And so what I thought we would talk about today is we're going to talk about the Rechthold case because it involves chemicals and the ability to try and solve a problem with those types of chemical problems, chemical industry. And then we're going to talk about Veris Gold, which is a gold mine. And then the third case is Tronex, which is much bigger than that and involves munitions and batteries and other additional environmental problems. Now, from our perspective up here, everybody on the stage is someone who is part of an award-winning case. So, for example, the three ladies on the stage are from firms that participated in the Veris Gold case, and that was nominated for and won the award for the sector, the mining sector deal of the year, and then it's also won the cross-border restructuring under $100 million. And so that's the award that we will be accepting tonight. And then Bob is an award winner for the Rechthold case. And so they were nominated for both the 363 sales as well as for the industry of industrial and manufacturing. And so it's a pretty interesting cross type of awards for a difficult industry in dealing with environmental problems. Now, we've divided our session up with, first of all, the conversation with Bob about Rechthold. And then after that, we'll talk about Veris Gold. And then after that, we'll talk about Tronex. So those are the three things. That's the way that we want to proceed. We are not going to cover how you physically clean up the property. We're not, because we're not specialists. None of us are in that area. We just hired good professionals and people inside the company to help us do that. We're not going to cover the technical aspects of any of the environmental laws because, again, those are so specialized depending upon the problems and which agencies. But we are going to talk about if you have an environmental problem for a company, there are different forums to be able to try and solve the problem in. The first case is a Chapter 11. The second case we're talking about was a Chapter 15, and it involved 4 different companies, 3 up in Vancouver. And so the CCAA was applied. And then the third one is a Chapter 11, but it's primarily about fraudulent transfer and being able to recover money so that you can clean up the properties. And it's very heavily agency related. So we are going to talk and look at it that perspective for our panel today. So let me get started with Bob talking about Reichhold. Go ahead and give us a brief summary of the Reichhold case and your role in it.
Reichhold was a 85-year-old billion-dollar basically manufacturer of composites and resins used for composites as well as coatings. It had 19 manufacturing plants around the world, operated in Asia, Europe, Latin America, and North America, and serviced customers in 85 different countries. Well, with an 85-year-old chemical plant, you can imagine that over the years they had certain environmental issues. Moelis was working with the company before our involvement, marketing it, and had very significant discussions with potential buyers who did due diligence, but really no one could close. And they determined after that process that they'd have to go into a Chapter 11 to really sell the company. We were brought in initially to be interviewed as a chief restructuring officer, but what we pointed out to them is it would probably be better if we had that responsibility without the title and stayed in the financial advisory role, because what we thought would happen was the foreign operations would stay out, the U.S. operations would go into Chapter 11, and we would be able to handle the sale because effectively Moelis would then be at the parent level. They wouldn't be able to handle the U.S. business, and that's the role we played. So initially what we did is you needed to prepare the company to see if you could get a stalking horse to go through a 363. It had environmental issues, which ultimately when the company filed, there was about $2.5 billion of filed environmental claims. I'll tell you what we settled out on those. There was asbestos and then unfunded pensions. So we had like the triple header there. The foreign operations were relatively clean, and the notes really sat at a Dutch holding company. So it gave us some flexibility in terms of structure. What we did initially is tried to create more of a runway and brought in a non-traditional lender. The regulated lender, which is a named financial institution, was sitting on an ABL facility, receivables and inventory. They didn't want to get anywhere near any of the fixed assets. We were looking for some additional availability. We couldn't get it. So we brought in non-traditional lenders. Oaktree put a facility in place, and that gave us some more runway to really plan this ultimately, which became a 363 process. Well, the company, that was put in place in May. We actually filed the company in the fall, September, and when the company was filed, what was interesting is Oaktree was prepared to do a DIP. We shopped the DIP. We had other non-traditional lenders, but the note holders who had a guarantee from the U.S. business, who were also sitting at the foreign entity, they didn't like the idea of Oaktree coming in and being the DIP lender because they felt they would give up a lot of their position. So it became a very competitive process. They came in, put in a market DIP. What was interesting on the DIP, and environmental had a big part of the structure, they did a senior DIP, which is just an in-the-box ABL, and then they did a junior DIP where they lent against the foreign assets, and then that money came in the form of a junior DIP into the U.S., not through the holding company because there would be tax issues with that, but direct into the U.S. business, into the debtor. So we had a senior DIP and a junior DIP. They also were the stalking horse for a 363 sale. So when we walked into court, and this was in Delaware with Judge Walrath, she was giving us kind of an interesting series of questions because there was a lot going on, and we were trying to get this senior junior DIP approved on a first day basis with our stalking horse was also the bondholders. Ultimately what happened is we marketed the company. We had a robust auction where we had a private equity firm bidding against effectively the note holders, and the large note holders here were Black Diamond, JP Morgan's bond funds, and Third Avenue. And after 71 rounds of bidding, we increased the price 51% over what the stalking horse bid came in. The case, when people were looking at it, the unsecured creditors didn't think they were going to get a recovery, and when the auction was over, there was about $24 million in the estate for unsecured creditors after covering all the secured debt, and 11 excess properties, which we didn't put in the auction because those were all former manufacturing sites that had environmental issues. And we knew no buyer would touch that. So that was something that we had a separate process to deal with, where basically what we did is after the auction was over, we basically retained Hilco to sell these environmentally challenged properties. The company had tried for years to sell them, but they were using commercial brokers who were very qualified but really didn't understand the whole environmental issues. And to date, those properties, there's been 8 sold, and that's created additional funds that have come into the estate as well. So those were some of the things. There were a few other things that we did that I think were creative. Is they had one plant in the San Gabriel Superfund in California that was a significant environmental liabilities. All the purchasers, even through an 11, didn't want to come near that. So what we did is we negotiated a prospective purchaser agreement with the EPA and the Department of Justice to say that the purchaser would make a payment, but if they made this payment, they wanted to know that they basically would get a free release and they wouldn't be considered a participating party before. I think the EPA and the DOJ rightfully determined that if they didn't accept this deal, the next deal would be we just would give them back the plant. They were able to negotiate about an $800,000 payment, which was pretty significant. What I'll point out, the significance of this liability is the parties that were participating parties had basically built 4 water treatment plants, and one of them was Aerojet, which is a very large aerospace company. 4 water treatment plants in the San Gabriel Valley to process water. So you can imagine what they spent over the years on that. We were able to do that. In between, when we negotiated that with the debtor, the prospective purchaser, and the U.S. government, there was a period of time where they have to notice everyone publicly. And we developed a tolling arrangement with the potential buyer where we told for them they didn't touch the assets because they only would buy it after they know the government would approve the settlement. We told for about 4 months, cost plus, with a profit for the estate, and then they subsequently closed about 4 months after we sold the company on that particular plant. And that served all the West Coast, and really they weren't interested in the company unless there was a solution for that.
So let me ask one question before we jump into the relationship with the agencies. When you were considering being the CRO of the company, was the environmental exposure as a potentially responsible party one of the things that you looked at?
That was a factor, and it was, although the company did have some insurance, and they had been good stewards over the years, it was something that we had considered, as well as the fact that we saw a sale coming and we knew that there would be a potential conflict if we were a CRO as well.
Okay. So then, since you aren't a PRP, I guess the next question is, what was the relationship with the agencies like? What was their compliance history, their day-to-day relationship with various agencies, state and federal?
What we found, what was very helpful in this process, is Rothschild had been a good steward over the years. They had paid almost $100 million for environmental cleanup prior to this time, had worked with state and federal agencies all over the country. So they had a lot of credibility. And on these excess properties that we were leaving behind that the buyers weren't taking, they were in discussions with them to say, we're just not going to abandon these. One of the things we did with a purchaser and the stalking horse is we negotiated a wind down budget that had significant dollars in there for environmental wind down. So it wasn't that we would just leave these in the estate and there would be no money. There are also, over the years, on a lot of the remediation, they had set up LCs in place to make sure that some of these properties would be taken care of.
Were bonds required, or did you have environmental insurance policies?
It was really LCs. Because of the size of Rothschild, they were able to have their financial institutions provide LCs.
So did the buyer have to provide its own LCs and financial assurance for the agencies?
The buyer bought the operating facilities, and there were only 2 operating facilities where there were some minor environmental issues, and yes, they had to put up some insurance for that. The properties we left behind, those were all that we subsequently negotiated after the sale, where some LCs stayed in place, as well as we worked out different solutions on each property. The interesting thing is, because a number of these properties were sold, there were buyers that were willing, because they had been remediated for a while, willing to step in and take the environmental liability for what it was worth, which was very interesting. Most of them were smaller entrepreneurial companies. You didn't see large companies buying this excess property. The best example I can give you is years ago I sold a company and 3M was one of the buyers looking at it. Flew in 20 people on 2 corporate jets, and the environmental people were basically walking around this facility with like spoons looking at dirt. And I said, what are you guys doing? And he said, listen, you might think that the issue here on your balance sheet's a $5 million environmental issue. He goes, the day 3M buys this company, that becomes probably a $1 billion issue because we're a deep pocket. We look at things very differently. So the buyers were not what I would consider to be deep pocket buyers, very entrepreneurial, and they found a way to get comfortable with the state agencies and the EPA.
Now moving on to the sale for just a second. There were 71 offers back and forth during the sale process. Tell us about the dynamics of that and why it took so long in that environment. Did you start too low with the price?
No, I think what happened is because we had an inside bid, which were very prominent note holders, and they felt that the buyer was just going to stop and they didn't want to leave any money on the table, and he was very robust and didn't stop. So they kept bidding increments and he kept bidding against them, and then finally at 3:30 in the morning he stopped. We started in the afternoon, but I don't think that they realized that he was going to be as aggressive, and I think what we realized is he understood where the state of the industry was and this particular company, how he was turning, and felt the U.S. business could be decoupled from the worldwide organization and still be a profitable standalone business.
So bottom line is, what happened to, how much have the secured creditors received through this process, and then what did the bondholders receive through the process?
Okay, the secured creditors were fully paid out, and the bondholders...
And was that through the financing or through the sales?
Well, the first round of secured creditors were paid out through the financing. The second round of secured creditors took out the first round. They were paid through the sale. And then the bondholders or note holders, they got both their senior dip and junior dip effectively through, they credit bid their junior dip. Senior dip was repaid through their effective purchase, and now they own 100% of the company on a worldwide basis. They actually are investing in this company. Company beat their forecast significantly, and they're doing pretty well.
Okay, so even though it was an environmentally distressed case, what's your overall advice or observation or recommendation in cases like this?
What I would say is, first of all, if you're going to be dealing with a sales process with an environmental company, you need to have liquidity because it's going to take a little bit longer to get this sale done. There's going to be more due diligence. You should have a robust data room with a lot of information on environmental, and you need to have the right experts that can deal with buyers and buyers' experts to get them comfortable that this environmental issue is not an insurmountable problem. You also need to be talking to the regulatory agencies early in the process so they're well informed, they know what's going on, that you can see that you're going to be cooperative and you're not going to dump a problem in their lap. I think that is very key as part of this process. And then if there's certain assets that you know are just going to be problematic but somewhat insignificant, try to pull them out and create a separate process for those so you don't taint the entire 363 sale or the plan process, if it's a sale through a plan, with some things that you know are going to be problematic. The other thing is if you have foreign operations, try to keep all the foreign operations out of the U.S. Chapter 11 if possible.
Okay, good. Let's move on to Veris Gold. And Annette, why don't you go ahead and do just a brief summary of Veris Gold and the roles the parties played.
Okay. Unlike in your case, Veris Gold had not been a good citizen as far as environmental compliance. And
It
that
had
was
no
one
friends.
What?
It had no friends.
Yeah, it had no friends anywhere, and it was a real problem. Now, you know, like Kathy, we do a lot of work in the mining industry in the West, and these mines they're major employers. So this was the major employer in the town of Elko, Nevada, well-known mine in Nevada. And so it had large environmental problems. It was owned by a Canadian company, and so it ended up in a cross-border situation where the Canadian parent was in a Canadian proceeding, and then put the monitor then asked for that for himself to be recognized in the American case in a Chapter 15 case. And originally, I came in, I represented kind of the financial part of the buyer. Kathy's client was the original DIP financer and original buyer, but needed a financial partner and also a partner that was very experienced in gold mining. So my client actually was a very experienced gold mine operator as well as the financial party that came in. Do you want me to give a history? This case actually began, the debtor in a Canadian proceeding, you have a monitor, but the monitor is not the debtor in possession. So the monitor doesn't, yeah, right, that's her client. The monitor did not have the power basically to act, for the company, more of an advisor. And so originally when the Chapter 15 was filed, that is the way it was set up. A sales process was run, nobody came in to buy the assets. So it was, a complete disaster as far as that was concerned. So when the banks then, the lenders went in and asked for the monitor to obtain expanded powers, so that the monitor in essence then became the seller of the assets. Not the operator, didn't want to be the operator to many environmental problems, but the party that controlled the sales process. And Whitebox, which was Kathy's clients, had come in and offered DIP financing that primed the pre-petition lenders and became the stalking horse bidder, and then began to look for, one of the conditions for closing the sale was finding an adequate financial partner, which came in the form of my client. So together we made this bid through a 363 sale and then closed the sale. And one of the other interesting things that happens in a Chapter 15 is because not everything applies automatically when a Chapter 15 is filed, there were certain things that had to be added into. So for instance, when Kathy's clients made the DIP loan, Kathy insisted, we got to have 364 apply because it doesn't normally apply, but that gave them the protections they need. And when we did the sale, we said, 365 needs to apply because we have contracts we need to assume. And so that then was imposed as well. So you have to be very careful in Chapter 15s to make sure that you've asked the court to apply certain aspects of the bankruptcy code that might not apply automatically.
And unlike Reichhold, which was a Chapter 11, the monitor decided not to file a Chapter 11 in the United States. The monitor was trying to stay as far away from all of the environmental liability as she could. There were gold mines that were also in the Yukon territories. And so it was very difficult. I mean, when the commodity prices go down, there is less cash for operating the business. When you have less cash to operate the business, you have to choose what you're going to pay, your employees, your taxes, your cleanup costs, the various suppliers that are involved, the people that are doing work on the project. So this specific case, because the gold prices had gone down significantly, it involved a really distressed a company that had a net operating loss on a regular monthly basis. And so the cleanup became important, but they then shorted their relationships. The relationships with the governmental agencies, because there you had the state of Nevada, you also had, it was on Bureau of Land Management and on Forest Service property, and you also had the EPA in there monitoring and watching what the NDEP were doing. They were kind of not shooting at each other, but they weren't cooperating. And so one of the things we found is that the lack of communication that a distressed debtor has with its environmental agencies just makes the problem that much larger. I laughed, Bob, when you said you've got to have a certain amount of liquidity because there are problems that occur constantly and the sale process takes longer. When my client Whitebox, which is a private equity firm out of Minnesota, that has done a number of environmentally distressed properties, and they've had to foreclose on them, so they're not shy of having to step in and take care of the problem and purchase it in a sale. As they were going through the due diligence and getting ready to file the sale motions and sign on the dotted line with the purchase agreement, there was a fire at the mine. The mine had 4 shafts in it, and the fire took place in the mill, so that even though things were being put on the ground, they could not mill. And the plant was shut down for 10 days, and that was a significant financial impact. So you had to have the liquidity to get through these environmental problems. Another thing that happened is there was a dust problem in the air, and MSHA, the Mine Safety and Health Act agency, stepped in and shut down the mine for several days until the dust problem is solved. And again, if you do that in the mill, you can't produce the product. It then ends up being able to be sold to generate the cash to do the operations. So I think having liquidity is important.
And all of that happened while we were doing due diligence.
Before your client stepped in.
Right,
But
but fortunately, because this was a client that really understood gold mining, it didn't scare them off. I
it
mean,
was
they
not.
understood
It was
those
not the
problems.
end of the world. Yeah.
Yeah,
but what it allowed is a party that was a private equity player to be able to realize that it needed a financial partner with even more liquidity than they had, so that together they would be a good, healthy financial history to provide to both the agencies as well as to the bonding company. The bonds became extremely important in this situation. Why don't you explain that?
Yeah. Well, let me just
Because they're
also-
not self-bonded. They had actual bonds and policies.
Right, because the relationships between the company and their regulators were so poor. One of the things that we had to do when we stepped in was basically pretty much promise that we would clean the slate after we bought this and come up with our own credibility in our history and environmental compliance with the gold mines that our client had operated elsewhere, along with a plan to deal with the environmental issues going forward, and a promise putting not only our operational history but our financial ability behind that we would make this better. And of course, in this situation, the environmental agencies, they were dealing with a mine that currently had no ability to really take care of its environmental problems. And because no other bidder had come in, the other alternative would be the closure of the mine, and then the environmental problems become the problems of the government. So there was a lot of incentive, I think, to work with this. And we were fortunate in having bonds, cash bonds, that bonded the environmental liabilities. And so one of the big one of the big issues that came up was we had to make sure that those bonds were transferable to us, because we as a buyer wanted to make sure that we had these bonds kept in place. And that, of course, helped us as well in getting the regulatory agencies not to demand a lot more, in bonds from us. So it was complicated in negotiating with the regulator, both the federal government and the state government, in dealing with AIG, who was our bonder, and kind of getting all of this pulled together so that we could move forward in a situation where the governmental agencies were assured, and we were assured, that we had the resources available to deal with the cleanup issues.
And the nature of the bonds, I mean, the amount of liability that had to be bonded was something like $80 million for the reclamation, and which is an extremely large amount for a buyer like my client, Whitebox, who only put in $12 million for the DIP financing, maybe $15 million by the time the sale actually closed. It would be almost impossible to come in and do $80 million worth of bonding. And so the relationship with AIG became extremely significant. And the thing that worked well with AIG was the level of communication, the financial ability of the purchasers that were coming in, and their experience. So that really what we needed to do for their benefit, and what we had to show them, is they had 8 years left on the bonds. And so we just had to show them that we could manage the cleanup process and work well with the governmental agencies so as to minimize the risk for them, and then they, in the long run, either we'd get new bonding, new surety companies, or we would be able to get to the end of the period, and we would then be able to negotiate for new bonds going forward. And so they were very at first, they did not want the insurance policies or the bonds to be assumed and assigned. And that was, again, another thing under a Chapter 15, the ability to do that in a Chapter 15. And so we were able to work consensually with them, just like we did with the NDEP. We were able to get rid of the consent order with NDEP. We were able to get rid of $20 million of penalties, and we didn't have to put up additional bonding. So the negotiations really went well. Now, the last issue that I wanted to cover.
And one other comment I would make on that is, it's interesting because the regulatory agencies, some worked well together and some did not. And you have so many different regulatory agencies involved. So like the NDEP worked well with the BLM. So that was pretty easy as far as
And the
some of
Forest Service.
Right, exactly. So those were easy. But the NDEP was completely separate with the DOJ's concerns about environmental liabilities. So we reached an agreement that got rid of the consent agreement, rid of the penalties with the NDEP, but that wasn't the same agreement that you had to reach then with the DOJ. And in fact, we're still working on finalizing our DOJ agreement. We have, an agreement in principle. Certainly part of that is taking responsibility for ongoing compliance. But it's difficult because they aren't, even though they're both dealing with environmental liabilities, they don't look at it the same way.
So then the last issue was the patents, because the patents at this mine were important because you couldn't operate without the patents. The patents were for equipment dealing with the mercury. And so it was something that had been developed while the employee was employed at the employer. So they should have belonged to the employer, but they didn't. The company allowed them to go to the employee. So then the employee was an employee of the Canadian company, not of the US company. So it really became a question not of Ninth Circuit case law dealing with the license and whether or not you were able to transfer a license, which in the Ninth Circuit, without the consent of the licensor, you cannot do that. So instead, we had to work under Canadian law in order to, and have the Canadian law first bless the transfer of the license. And so once we were able to work with the employee, get the transfer of the license blessed by the Canadian court, then the US court had no problems. Although at many of the hearings prior to this, he really was concerned and had expressed that it really wasn't something that he could deal with. And so we found another way to deal with it through the Canadian entity instead of through the American entity. And then in the long run, what happened is the sale did take place. Annette's client and my client are the proud owners of a gold mine. And we, at the same time, the monitor then dismissed the cases, and the monitor also abandoned the Yukon Territory mine back to the province. So the Yukon province then, and the insurance company and the mechanics lien holders have to deal with those problems up in Canada, but they were able to sell and take care of the US assets, but just not the Canadians. There was nobody who would buy or be creative or come up with the solutions that were necessary in Canada. We looked at those issues, but we weren't able to do it.
Yeah, we kept an opportunity to acquire them, but they were just too difficult to work out.
So now, Dawn, tell us about a completely different type of situation, and one where this is not the way to do it. Always turned out to be successful,
way to do it.
and it involved a lot of negotiations and communications and working with the agencies. So tell us about yours. Who did you represent in Tronox?
So I represented the state of Nevada in Tronox, and it was a very interesting case. Kerr-McGee was one of the biggest chemical companies in the world, and over 40 years, starting in the late 1920s, they acquired gas stations, oil refineries. They began uranium mining on the Navajo Nation properties. They had 33 wood treatment plants that used creosote. In the 40s, they bought a company called American Potash and Chemical, and that company owned, among other horribly obnoxious plants, a plant in Henderson, Nevada. And Henderson is really what they call the southeast corner of Las Vegas. It's about 3 miles away from the airport is where it started. And they made rocket fuel there using ammonium perchlorate, which then trickled down into the Las Vegas water table, which flows directly into Lake Mead in the Colorado River and goes to Arizona and California. All in all, they had 2,700 environmental legacy sites in 47 states and 7 federal Superfund sites. So, starting in 2000, they hired Lehman Brothers to separate their chemical operations from their exploration and petroleum operations. They wanted to create the E&P company solely, and then they wanted to create what became Tronox to operate the chemical business and to take the legacy liabilities. Just to give you an order of magnitude, from 2000 to 2005, the E&P business generated $5.2 billion, and the chemical business generated $312 million. During the same period, they incurred over $1 billion annually in environmental remediation costs, and they had tort claims. They settled about half of them for about $100 million, had another 10,000 filed, with more being filed on a daily basis. So in 2002, Anadarko came along and looked at merging with Kerr-McGee, but they said, look, all of your free cash flow is going to pay these environmental response costs, and we don't see that changing except getting worse over the next 30 years. So Kerr-McGee started working with Lehman Brothers, and by the end of 2002, they completed 11 transactions, which separated the E&P business from the chemical business. Because they had consolidated financials, this was not really clearly disclosed. There was a footnote in the 2003 10K that said Kerr-McGee distributed investments in primarily oil and gas into a newly formed holding company and merged into it. I mean, that was the sum of the disclosure. The complete spinoff, however, didn't actually occur until 2005, where they had a master separation agreement. They made it clear that Tronox was responsible for all of the environmental claims, but they backdated those documents to 2002. Shortly after that, Kerr-McGee was acquired by Anadarko for $18 billion. Prior to that, they had obtained financing for Tronox on a standalone basis. There was a $450 million facility, 250 of which was revolving, and there was $350 million of unsecured notes. But all but $40 million of that was upstreamed to Kerr-McGee. So Tronox got $40 million. And they then did an IPO, and Kerr-McGee got another $226 million from the IPO, but they kept control over Tronox. They gave Tronox $100 million in environmental indemnities over 7 years, but it wasn't triggered unless Tronox spent a certain amount in remediation costs. But because they had a couple $100 million net loss every year, they obviously weren't in a position to do that. They also left Tronox with about $700 million of unfunded liabilities, pension liabilities and employment liabilities. In 2006, Tronox expected to sell. They were part of a joint venture in Henderson that owned about 900 acres that had been remediated largely and was vacant, and the joint venture had an agreement to sell that land for $515 million. But when the buyers came in to do the due diligence and talk to the NDEP, the Nevada Department of Environmental Protection, they backed out. Apparently, the remediation was okay for it to be vacant land, but the goal was to build houses and a casino on it, which would have required immensely different remediation at a much higher cost. So in 2000...
It smells to me like fraudulent transfer. So Tronox, how did they get into a Chapter 11? What happened? What triggered it?
So by 2008, they decided, yeah, this is not going to work. They hired bankruptcy counsel. And in 2009, 6 years and 13 days after the separation, they filed for Chapter 11. And the first thing they did was to sue the former parent for fraudulent conveyance. So in order to confirm its plan, Tronox needed to deal with these environmental legacies. So there was a big group of people negotiating a settlement. There were about 17 states that were actively negotiating. The federal government was actively negotiating, and the state of Nevada was one of the states that was actively negotiating. But most of the people sitting at the table were environmental lawyers. They were the EPA's environmental lawyers. They were each state's attorney general office that ran that state's environmental department. And there wasn't really a lot of a bankruptcy sophistication on that side of the group. So the state of Nevada was able to say to Tronox, look, you need to pay our bills and we're going to hire a bankruptcy lawyer because we don't really understand this whole fraudulent conveyance thing. And so we're not going to take a deal that relies on that. And Tronox really had to get us to buy into the litigation, the fraudulent conveyance litigation, or else they were never going to get a deal done. So we did, after over a year of negotiating, made a settlement agreement that provided, it was $270 million initially at the plan effective date, and it went to 6 participants. The EPA received $59 million. There was a multi-state trust created, which received about $70 million. The West Chicago Environmental Trust received $10 million. There was an Oklahoma trust that got $8 million, a Savannah trust that got $7 million, and the Henderson trust that I represented got $81 million. And then the environmental groups also got 88% of the litigation proceeds from this fraudulent conveyance litigation. The other 12% went to all the tort claimants. There was a 34-day trial. The principal claim
On the obviously,
fraudulent
transfer.
on the was that it was.
Well, before you get to that portion of it, in talking about stage 1, because the litigation and the actual suits are stage 2, in stage 1, what I liked was the strategy that the claims bar date was set. All of the environmental agencies had to file their proofs of claim, which are normally contingent claims.
Right.
But they filed their proofs in order to let everybody know that it's about $5 billion worth of potential contingent liability for the cleanups of all of the 2,800 sites. So then with that gorilla in the room, you still had toxic tort claimants, which we have in a lot of these cases too, as well as future claimants, that you then were able to figure out, if we got money, how would we split it up? And then they split the money up in the percentage. And then under the plan, which was your stage 1, you then were able to take control of the litigation, as well as get enough money funded into the trusts so that the trusts could bring the lawsuits and be aggressive on the lawsuits against the parent. So now, stage 2. So you set stage 1 with taking control, understanding the scope and the nature of the liabilities. You just need cash to do the cleanup because the debtor's not doing the cleanup. You're going to be doing the cleanup. So now, stage 2. Tell us about how what the damages claim turned out to be, and then how that turned into a settlement that got your clients $1 billion.
Well, one of the interesting things about the proof of claim was they were set as far as Tronox and the plan were concerned, but they could be amended to reflect, actual costs after the experts had gone out and made findings. That wouldn't affect Tronox, but it would affect the damages portion of the trial. So they were able to be amended for that specific purpose.
Oh, and meanwhile, here was another question I had for you earlier. Potentially responsible parties include the officers and the individuals that handle any of the cleanup or any of the contamination at any of the sites. And to me, that's a huge leverage that any of the governmental agencies have. What happened with that? What happened to that leverage?
They got released.
In the bankruptcy plan itself?
Plan,
well, there
they got
went the
released.
Negotiations on that one. Okay, go
But
ahead.
that was that was our agreement on the way the plan was written. Included a lot of things like that. Those were just negotiated terms. The real big issue, though, was trying to get the government and the other states and the Navajo Nation to buy into this litigation.
Yeah.
And primarily what we said was, look, we think this is going to be at least $1 billion. We can hire a really good law firm. They wanted a small upfront payment of $32 million and took a small, under these circumstances, percentage, like a 7%
Contingent?
contingency fee, yeah.
Because that would have been the goal in the first place, is just get it on
Right.
100% contingent fee with paying expenses.
Right, and,
Okay,
yeah.
so now, skipping ahead just a little bit, the judge ended up ruling,
Well, what he said was, there was the first issue was the statute of limitations. Was it a 4-year, it was Oklahoma, because that's where their headquarters were. Was it 4 years? Or because of the federal government and the debt collection, was it 6 years? And could you tag the federal government statute onto 544?
and when did it start and when was it discovered? So,
And
right.
and so and then the second question was, when were you stuck with the 2005 date, which you clearly could get to under the 4 years, but you really needed to go back to 2002. And so what the judge did was looked at what had happened, the fact that the financials were consolidated, that the creditors could look at Kerr-McGee. He looked at the intent of the parties. He looked at all of these factors, the substance, to say, yes, this didn't really happen until 2005. And with that, he went through the actual fraudulent conveyance and virtually found every badge of fraud. And then he went through constructive fraud. And primarily, Judge Grapper, I think, did that because this was the liability phase of the trial. And the other side really did argue with a straight face that, yes, it was reasonably equivalent value to give them $40 million. And, roughly, I don't know, $5 to $15 billion of environmental legacy, and that was fair. And they argued that seriously with a straight face.
So then, we only got a couple of minutes left, so the damage claim was?
The judge said it was going to be between 5 and 16 billion, and we settled for 5.15 billion, of which my client got a quarter.
Okay, so they paid their cash beginning of 2015.
Yep, beginning
And
of
the state of
2015.
Nevada, then what is it going to do with its $1 billion?
Well, so the state of California decided that your perchlorate count in your water can only be, 0.00001%. The federal government says, no, it could be, 0.02%. So most of it is going to go to remediate the perchlorate count and keep the perchlorates from leaching into the water table, which is a fairly significant undertaking.
But it's really important. Water is so important to the western
Right.
states. California, as we know, because of the droughts.
Right.
So you're going to put that in and be able to remedy the water table and the leakage into the Colorado.
And all of the sites and the other properties that Tronox graciously gave the state of Nevada as part of this settlement.
Oh, taking title to
Yes.
the properties. The debtors did not want to clean them up, okay.
Right, but they did lease back the one plant that they're operating, but they don't have to clean it up.
They make a profit off the land, but they don't
Right.
have to clean it up.
And if we can't use it all for that, then it goes to any other environmentally bad site in Nevada. If we can't use it, then it reverts to the federal government.
I don't think that's going to happen.
I don't think so either.
So the lessons to learn from the Tronox case are what?
Don't be so blatant about, having a spin-off whose sole purpose is to ditch the environmental liabilities. I mean, they had slides that they showed the board, and there were books that the investment bankers then, they basically said good Kerr-McGee and bad Kerr-McGee. And and at the time of the trial, the good Kerr-McGee was worth $60 billion. So.
Well, and so then the other lesson, besides not doing the transfer in the first place, is what?
They probably ended up way better off than they ever could have. They sold Kerr-McGee for $18 billion. They only had to pay $4 billion or $5 billion for the liabilities, and now they have a $60 billion market cap.
So for them, it ended up being a good decision from a business perspective, maybe not from a corporate governance or corporate citizenship. The other thing that I learned from watching that example was the importance of the governmental agencies working together, but also taking control of the litigation rather than letting the debtor do it and having to supervise the debtor with its already tainted record, and the releases that were given so that they didn't have as much of a personal stake. And so I liked the mechanism set up in the strategy between 1 and 2 in order for the states and the EPA to take control.
And many of the states, after the settlement, said that they absolutely should have hired their own bankruptcy counsel and not had their in-house state
Well, that's a
people
good
do
plug
it.
for us, doing
Yeah.
bankruptcy law, that we become invaluable to the states. Now, just to kind of pull the 3 cases and the issues together, one of the interesting things to me is yours was a Chapter 11, you kept out the foreign companies. This Veris Gold was a Chapter 15, no 11. They could have done an 11 by the monitor, but getting the debtor out and having the monitor step in order to now sell it was helpful, in addition to the other parties that came in order to buy and found an opportunity to buy at a very distressed price.
And the case was dismissed, right? Without
Yes,
the
15s were
plan.
dismissed,
Right.
right. And then,
Well, in fact, if you wanted to file a plan, you'd have to file a Chapter 11 to do it. So,
yes, that's right, you could
and they
not do it in
did decided
15,
not to
right.
do that.
But it was, and yours, Bob, was in Delaware, right? And the Veris Gold was in Reno, Nevada, and in Vancouver. And then yours was in the Southern District of New York. And so different forums. Just to add a slightly different touch, I represent a South African bank in southern Arizona for a copper mine in southern Arizona that between the borrower and my client, they decided that we'd do a state receivership. So we did not choose to do a Chapter 11. Instead, we did a sale, free and clear of liens, in a state receivership, and was able to find the buyer and manage a sale process and get the state court judge to bless it. And the receivership order became important to limit the liability of the receiver for any of the aspects that might take place as a PRP. And then in addition, what we built into the receivership order, and Annette has done this as well, in the receivership order, you build in a provision that says that the board of directors who blessed the receivership order and who agreed to it and signed on to it gave up all authority to file and delegated their responsibility to file a bankruptcy to the receiver. So the receiver was the only one that had permission to do that. So we were an hour before the receivership sale hearing was to take place, and of course, the board, who had agreed to this, then decided to file their own Chapter 11, and they filed it. We did get the case dismissed within 9 days. We were able to finish the sale and go forward and close the sale in December of last year. Whether that clause is enforceable or not, we were able to get the debtor to finally back down, and maybe because of the sanctions that were being threatened for it, and because we had been in receivership for over 120 days, it created a mechanism and at least something to argue from that kept it out of the Chapter 11 and kept it back on the state court receivership where the parties had wanted to do it in the first place. But there are different forums, there are different places to handle these things, and to me the most important thing in these, a lesson to learn from these, are the creativity that is necessary when you're dealing with an environmental problem. I represented Texaco in the El Paso refinery case, and Texaco was the prior owner and got sued for the environmental contamination, and we had cleanup obligations that we tried to make restrictive covenants that ran with the land, that would run with the land. And so you can come up with mechanisms and think about these things and work through the issues and find the best solution. And you can also sometimes give the wrong advice, as happened in that last case, and give the wrong advice and it really create a different kind of focus and a different solution. So any other final observations? Let's start with Bob. Any final observations, because we've got to close.
Yeah, I just think that planning on, if you're in a process, who your buyer is, making sure they understand. You don't want to waste time with people who don't understand
Right.
environmental issues, because you can go through a long process and then they don't get comfortable.
Right. And they have to understand that you solve environmental problems through the operations going forward. And if you have sufficient funding and you have sufficient ability to do it and communication and relationships, you can do it. It shouldn't be an obstacle for them.
Right. And communicating with all the regulators through the process and not waiting to the end and saying, okay, I have a transaction, this is what we're going to do. It's just not going to happen.
And I would say the difference between having a good citizen that comes into a Chapter 11 or a Chapter 15 or receivership is huge compared to a bad citizen coming in. And when you are faced with a company that has a history of non-compliance, clearly does not have the financial resources to do it, you pretty much, in order to work out things with the regulatory agencies, are going to have to clean house. You're going to have to bring in someone with credibility, someone with financial resources, and start all over again. And it's hard because it's really complex. One other comment on receiverships with respect to them versus Chapter 11s, a receiver is one way to get a new party in.
Yes.
Without, because a Chapter 11 isn't necessarily going to bring you a new party, and give them only partial responsibility so that they're not taking responsibility for the operations.
And historically, a receiver is someone who only
Right.
takes possession
Right.
of the funds from the operation of the business. They don't run the business, but
Right.
you have to sometimes structure them slightly to your advantage to get that leverage.
Yeah. And the one issue with that is state court receiverships are usually equity receiverships. Some states like Minnesota have a very good receivership statute that allows sales free and clear. But if you don't, a lot of times you're going before a state court judge that may or may not understand receiverships. So when you go before a bankruptcy judge, of course, they understand all the principles of sales free and clear, but it's a little bit more difficult, and you take a bit of a risk when you're in state courts because they may or may not understand it, and you may or may not have precedent to do sales free and clear, and that is critical in environmental cases, even though operationally you're going to be forced to comply going forward always.
So Don, closing remarks?
I think you have to get the regulators involved early. If you don't have a receiver or a monitor or some other third party, use the bankruptcy lawyers and explain what's going to happen and explain the plan and get them on board, because they can stop it. They can say, no, we're not going to let you sell it to that person.
That's right.
So it's really important to get them involved.
Yep. Well, as you can see, the two award winners for Veris Gold and for Reichhold had very complicated matters to deal with, solved it with creativity, and I congratulate my fellow winners up here on the stage, and I appreciate all the time you guys put in doing the panel with us. Let's thank our panel.